Good afternoon, everyone. I hope you can all see and hear me. If there are any issues, just drop a message or shout out. Thank you for attending our webinar on unlocking estates and jointly owned properties. My colleague Chris, who's just over here, I'm going to tilt the camera in a minute, is going to be looking at orders for sale and equitable accounting. And then I'm going to be looking at disputes over beneficial ownership and specifically common intention constructive trusts, and then the recent Court of Appeal decision in Hudson and Hathaway. We're going to be looking at all of this, in a bit of the context of these disputes arising in relation to an estate property. For the purpose of the talk, we'd be grateful if you could stay on mute with your cameras off. There'll then hopefully be time at the end for any questions. So without any further ado, I will pass you over to my colleague, Chris, who's going to crack on.
Hi, good afternoon. I'm Chris Hatton. So during my part of the presentation, I'm going to be looking at, as Tom said, orders for sale, first looking at the statutory framework, then the matters to which the court is to have regard, and finally some practical considerations around bringing those claims. I'll then move on to look at equitable accounting, the three areas of occupational rent, mortgage payments, and improvements to a property. So for the section of the webinar dealing with orders for sale, I produced this scenario. Mr. A and Miss B purchase a property together for them to live in with their son. They live there happily for a number of years, but the relationship breaks down and Mr. A moves out. Miss B wants to continue to live there with their son. However, Mr. A wants to realise his interest in the property and purchase a different property. And the question I pose is, how can they overcome that deadlock? As I'm sure most of you, if not all of you, are aware, there's a piece of legislation known as the Trusts of Land and Appointment of Trustees Act 1996, which is commonly referred to as TOLATA. And I guess the first question to ask is, well, what is the Trust of Land? And Section 1 says that a trust of land is any trust of property which consists of or includes land. So essentially that would be land that's held by a legal owner or legal owners on trust for one or more beneficial owners. Section 14 of TOLATA gives the court the power to make orders relating to the exercise of trustees' functions or to declare the nature or extent of people's interest in a property. And obviously one of the most common orders we see under Section 14 is an order for sale. Now turning to who can make an application for an order for sale, Section 14.1 says that any person who is a trustee or any person who has an interest in the property that's subject to the trust can make that application. Ordinarily, this would include cohabitants who are trustees, beneficiaries of the trust, or secured creditors. Then there are certain factors which the court has to take into account when deciding whether to make an order for sale. These are listed in Section 15 of TOLATA. They include the intention of people who created the trust, the purpose for which they purchased the property, the welfare of any child who lives there, the interest of any secured creditor of any beneficiary, and the circumstances and wishes of any beneficiaries. In Section 15.3, it essentially says that if there's a dispute between the wishes of the beneficiaries, in those circumstances, the court would take into account the majority wish in accordance with their combined interest in the property. Now, bear in mind that none of the factors under Section 15 carry any greater weight than the others, and that the court is also entitled to take into account any other factors that it considers are relevant. Now, one of the questions that we get asked is, well, what about if one of the parties to the dispute is a personal representative? And Section 18.1 of TOLATA says that whilst most of the provisions of TOLATA apply to personal representatives, Sections 10, 11, and 14 do not. And as I said at the outset, Section 14 is the section that gives the court the power to make orders in relation to a trustee's function. And what that means is that if a beneficiary is trying to bring a TOLATA claim, they would not be able to do so because at the time the estate administration is ongoing, they do not have a proprietary interest in any specific assets within the estate. Essentially, whilst the administration takes place, the assets vest both legally and beneficially in the personal representatives. And so that means unless the beneficiary has a separate interest other than his entitlement under a will, in those circumstances, it would not be appropriate for the beneficiary to bring an order for sale or a TOLATA claim. However, if a disagreement does arise between a personal representative and a beneficiary, the beneficiary could, of course, make an application under CPR 64 either as a straightforward administration dispute or for directions from the court as to what should happen. Do bear in mind that Section 18 does not prohibit personal representatives from bringing or defending till lata claims on behalf of an estate. Now, the most common claims we see for an order for sale are those between cohabitees. So if we go back to my scenario at the outset of this matter and apply the Section 15 factors, obviously the intention of the purchase of the property was for it to be a home for the family. Now that Mr. A has moved out, that purpose has ended, which might lean towards ordering a sale of the property. Obviously, as we know, Mr. A and Ms. B have a child. The court will take into account their circumstances. So, for example, if the child is going through the education system, the court might determine that sale should be deferred until he finishes his education. However, the court is realistic about the need for downsizing. So, for example, in the case of the mortgage corporation and share, Mrs. Share had a 75% interest in the property, and the court determined that that was more than sufficient to find alternative accommodation for Mrs. Share and her son. Some practical considerations around bringing applications for an order for sale. There's a question as to whether it could be brought as a Part 7 or a Part 8 claim. Really, if the only question that the court is asked to be determined is whether there should be a sale of the property, in those circumstances, it will be appropriate to bring it as a Part 8 claim because there's no substantial dispute of facts. However, usually there are other matters that need attention, such as children, or even disputes over the extent of a person's interest in the property. And in those circumstances, it would be appropriate for it to be brought as a Part 7 claim. Now, there are some advantages to a Part 7 claim in that your claim and defence are fully pleaded at the outset in your particulars of claim and your defence. However, if the party who is looking to bring an application for an order for sale, Part 8 would be more advantageous because it has tighter procedural timescales. You have your acknowledgement of service together with your supporting evidence within 14 days. Obviously, the defendant could object to the use of Part 8. Within his acknowledgement of service, there's a section for doing so. And obviously, of its own volition, the court could make an order at any point that the claim should be treated as if Part 8 did not apply and it had been issued under Part 7. Some further considerations, well, where should you bring an application for an order for sale? It could either be issued at the High Court, be assigned to the Property Trust and Probate list, or you could do so at a county court. The High Court would be more appropriate if the property was particularly valuable or if there were particularly complex elements to the claim. However, we do find that quite a number of cases nowadays get transferred out of the High Court and into county court hearing centres. As to costs with orders for sale, if it's a Part 7 claim, it will most likely be allocated to the multi-track, and provided the case is of the value of less than £10 million, in those circumstances, your precedent H cost budgeting would apply. With Part 8, it would only be if the court orders so, and in all other respects, the general cost rules apply equally to both Part 7 and Part 8 claims. So obviously costs would follow the event, although the court does have discretion when it comes to costs. In terms of what the order might look like, whilst there isn't a prescribed form, the following is a non-exhaustive list of things that you may wish to have incorporated into your order. Obviously, if the court orders that a sale should take place, it would say so. The parties may agree the sale price or a provision for determining the sale price, maybe that the property is listed at a certain price, accepting offers over another price. The court will probably order which party is to have conduct of the sale. This is usually just to avoid future disputes around the property. There may be a provision for which estate agent is to list the property or which solicitor should undertake the conveyancing. And then finally, you would want your order to make provision for how the proceeds of sale should be applied. Ordinarily, if there's a mortgage, this would be redeemed first, followed by payment of properly incurred disbursements, solicitors' fees, and estate agent fees, and then finally distribution to the beneficial owners in their relevant shares. I'll now turn to talk about equitable accounting, which was quite nicely summarised by Lord Justice Griffiths in the case of Bernard and Josephs. To summarise, when proceeds of sale are realised, you need to undertake an equitable account. If a woman has left, she should be entitled to receive occupational rent, whereas if a man has paid the mortgage payments, he should be entitled to a credit for the woman's share of the payments. If he has spent money on redecorations resulting in a better sale price, he should have a credit for that, not by way of an altered share, but by repayment of the whole or part of the money he has spent. And essentially, equitable accounting is an attempt by the court to achieve a degree of fairness between the parties. And when it comes to an equitable account, the court does have a wide discretion. It would ordinarily apply in circumstances where one of the parties has left the property and the other remains in occupation, and the applicant is asking the court to decide whether they are owed money in addition to their share of the proceeds of sale. Now, one thing to bear in mind is that equitable accounting can only take place once the extent of the party's beneficial interest has been determined. So if there is a substantive dispute or a Talata dispute under section 14 as to what the party's beneficial interest in the property is, equitable accounting cannot take place until that has been resolved. Generally, there are three areas that the court will take into account. These are occupational rent, unequal mortgage payments, and improvements to a property. I'll first look at occupational rent. So section 12 of Talata says that a beneficially entitled person has a right essentially to occupy their property. And if that right is restricted, then the party who is in occupation could be liable to make a compensatory payment for that restriction. That's under section 13 of Talata. Bear in mind, there is no automatic right to occupational rent. It is a discretionary remedy that the court may apply. Historically, there was a need for one party to restrict the other from living there. That's been softened slightly, even going as far in Amin and Amin in 2009 to say that a threat or a general unpleasantness is likely to be a sufficient restriction for the purposes of applying occupational rent. In terms of quantifying what the occupational rent level should be, ordinarily it would be the rental value of the property when placed on the open market, obviously then reduced in accordance with that party's beneficial interest. So going back to my scenario at the outset, let's say for the purposes of this that Mr. A and Miss B own the property equally. Mr. A, having moved out, would be seeking occupational rent from Miss B at 50%. I put a query as to whether the cost of alternative accommodation could be a measure for quantifying occupational rent. I think that's probably unlikely. The nature of occupational rent is to be compensatory, really for that restriction rather than anything else. Then we look at the case of Jones and Kernot, which went to the Supreme Court in 2011. And some of the commentary suggested that cross claims between the parties are likely to be appropriate. So if one party is claiming occupational rent, the other may be entitled to claim for mortgage payments. Bear in mind that in the case of Jones and Kernot, that is not the approach the court took. They looked to the matter in the round and took a proportional approach. They did say, however, that if a party that is in occupation is paying all of the outgoings of the property and there are children living at the property with the intention for it to be their home, in those circumstances, the court is more likely to determine that occupational rent should not be payable. I'll now move on to look at mortgage payments. The court does draw a distinction between interest-only mortgages and repayment mortgages, and that's essentially because with an interest-only mortgage, you are paying interest to the bank rather than adding any equity to the property. So with the case of Re Pavlou, Mrs. Pavlou remained in occupation and she was making capital repayments towards the mortgage. The court found that Mr. Pavlou should not be entitled to take advantage of the increased equity that Mrs. Pavlou had paid by paying those capital repayments. Again, with mortgage payments, I just put a note that you may wish to consider cross claims for occupational rent as mentioned in Jones and Kernot. The final area for an equitable account that the court will take into account is improvements to the property. Again, there is a distinction drawn between what the court considers to be cosmetic improvements and general maintenance, and more substantive improvements such as structural extensions, loft conversions, kitchens, bathrooms, things that are actually going to add substantial value to a property. In terms of quantifying the level of improvements to the property, it's usually calculated by reference to the actual cost of doing the work and then the increased value to the property as a result of those works. In the case of Re Pavlou said that normally the non-paying owner would contribute a percentage of the lower of those two figures. Now, the party claiming an equitable account in respect of improvements to a property would need to evidence the cost of those works. Usually that would be by way of builders' invoices or receipts, and of course the added value to the property as a result of those works. Ordinarily that would be a valuation with the works done and potentially a retrospective valuation of the property without the work done. One final thing to bear in mind is that the court will only take into account improvements that were made after the period of cohabitation comes to an end. So if one of the party furnished improvements to the property solely during the course of the cohabitation, then that is not something that would be appropriate for the court to take into account under an equitable account. I will now hand over to Tom.
Thank you for that, Chris. So I'm now going to be looking at disputes over beneficial ownership, and specifically how these disputes might arise in the state context, the kind of things that we see coming in day in, day out. Just some procedural points. Chris has covered that quite extensively, so I won't go too much into that. And the common types of claim that we see, and then a focus on common intention constructive trusts, and then kind of leading into the Court of Appeal's decision in Hudson and Hathaway. And then finally, just some pointers and a discussion of how PRs might wish to deal with any potential claims involving the estate, and what kind of things they should consider in terms of risks and costs and things like that. So in an estate context, we see these disputes arise in a few ways. I mean, this isn't a kind of exhaustive list, but it's often a scenario where a beneficiary or another person is occupying the estate property, and the PRs wish to take steps to obtain vacant possession and sell it in the course of the administration. And then in response to that, this individual raises some kind of allegation or counterclaim that they have a beneficial interest in the property, meaning it shouldn't be sold, or and actually belongs to them. Other scenarios might involve a property that was jointly owned by the deceased and another individual. This, in my experience, is typically one of the children, and that child might then argue that, despite them being both on the title, they actually own the entire beneficial interest, or conversely, the other beneficiaries and children might argue that despite this other child being on the title, actually it all belong to the deceased. And then finally, a scenario which isn't that unusual, and I had a recent kind of referral where this cropped up. The family and the beneficiaries understand that a particular property and perhaps one that the deceased was even living in belonged to the deceased, and that was the understanding in the family. And then they go and see a solicitor. The solicitor gets an OC from the land registry, and it turns out that it's registered in the name of another individual. And then there's a consideration of should a claim be brought on behalf of the estate to recover that asset. Moving on to some very brief procedural points. As Chris said, when you're bringing a claim for a declaration of beneficial interest, you're asking for an order under Section 14 of Talata. Part 7 procedure is the procedure that should be used unless there's unlikely to be a substantial dispute of fact. And of course, when you're talking about beneficial interests in a property being disputed, it's hard to kind of see a scenario where Part 8 procedure would be appropriate. If this issue is raised in response to, for example, a Part 8 application for an order for sale, then the proceedings are very likely to be transferred to Part 7. It might either be kind of put on the acknowledgement of service, or the court might make that order of their own volition. And in an estate context, the claim will be brought or defended on behalf of the deceased estates, generally by the PRs. It's well established that all causes of action which vested in the deceased survive them for the benefit of their estate. And so, executors wishing to bring this claim on behalf of the estate derive their authority from the will, although it might be good practice to wait for a grant just in case there's any arguments over the validity of that will or standing. In terms of an intestacy, administrators do need to wait for a grant before issuing proceedings. If the claim is brought against the estate, then Part 1912(2)(a) of the CPR provides that where there is a grant, the personal representatives should be named as the defendants. If there is no grant, somebody can still bring proceedings, and it would be against the estate of the deceased. But an application then needs to be made to appoint somebody to represent the deceased estate in the proceedings generally. That probably should be done at the time of issue just to get it sorted. It certainly needs to be done before service, because otherwise there's going to be nobody to serve the proceedings on. Moving on to common types of claim, which you'll all, I'm sure, be very familiar with. The first is an argument that a constructive trust has arisen, and broadly speaking, this is an argument that the beneficial interest is different to that suggested by the title due to a common intention or understanding between the parties, and then a change of position or detriment based on this understanding. Secondly, an argument that there's an implied trust, a resulting trust in place, which generally arises due to direct financial contributions to the property, typically to the purchase price, which were not a gift. And finally, proprietary estoppel, which is essentially asking the court to grant relief where it would be unconscionable for an assurance relating to the property ownership not to be upheld, which the claimant has relied on to their detriment. And of course, each of those kind of topics warrant very extensive kind of talks, and even the specific elements of them in their own right, which clearly don't have time to go into today. But what I will do is touch on common intention constructive trust a bit more, to then lean into Hudson and Hathaway. So when we're looking at a common intention constructive trust case, the starting point always has to be, is there an express declaration of trust in place? Typically at the time of purchase, were the boxes on the TR1 relating to joint tenancy or tenants in common and equal or unequal shares ticked at the time? Is there some other deed that was executed by the parties? If there is such a document in place, or the boxes were ticked, or some kind of trust, then that is generally conclusive, unless, and there's a quote there from judgment in Gaspar and Zaleski, those interests were subsequently varied by deed or by the operation of a common intention constructive trust or of a proprietary estoppel. Where there is no express declaration of trust in place, which is often why these cases end up with solicitors and before the courts, then it's well established that in a kind of domestic setting, there's a rebuttable presumption that equity follows the law, and the burden of proof is on the party seeking to establish that the beneficial interests are not equal or different to that suggested by the title. And obviously that something that was reaffirmed in Stack and Dowden. And what that really means is where there's two people on the title and a particular box isn't ticked and it's unclear, then the presumption is equal ownership and joint tenancy. Where there's only one person on the title, the presumption is that that person owns the entire beneficial interest, and the burden's on the person arguing against that to prove that. Beyond this, it's also kind of long understood, and we'll get on to Hudson and Hathaway in a minute, that there were two elements which really must be established for a common intention constructive trust to arise: some kind of agreement or common intention between the parties, and then a change of position or detriment in reliance on this. And there's a quote there from Lord Bridges' judgment in Lloyds Bank and Rossett, which I'm not going to read out, but is a kind of helpful summary of how the court looks at those two elements. As we'll get to in a minute, how the court actually gets to establishing the agreement, is subject to how they look at it. And sometimes they look at that second element first. If the first element of common intention agreement isn't clear, they can look at the second element of detriment and conduct and change of position to then either infer and impute what the agreement was. But generally there are those two elements. And when we're talking about detriment, it doesn't necessarily have to be financial, but the classic thing would be contributions to the mortgage, over the years, contributions to things like repair and renovation works. And when we're talking about kind of non-financial detriment, it might be things like providing care, or giving up career prospects or the right to bring some other kind of claim. And so moving on to the approach that the court takes, kind of taking all of that into consideration, Lord Walker summarised this quite helpfully in the Supreme Court's decision in Jones and Kernot, which you'll find slightly paraphrased but listed on the slide here. As per Stack, the starting point is that equity follows the law, and then it's about displacing that presumption. I'm not going to kind of read out this slide in its entirety, but essentially what the court will do is, look for any evidence of a common intention or agreement. Are there emails? Are there messages? Is there credible evidence of oral discussions which set out kind of what was agreed between the parties and accepted? If that is established, then they would look at the second element of reliance and detriment and a change of position. Where that first element isn't clear and there isn't that clear element, clear agreements, then the court, as per point 3, can infer what the common intention or the agreement was with an objective kind of assessment of the conduct and the change of position and what actually happened. And where that doesn't kind of lead to it, as per point 4, the court can potentially impute kind of what the intention, the agreement was based on, as per the end of that point, and what it considers fair, having regard to the whole course of dealing in relation to the property. And the cases of Stack and Dowden, Jones and Kernot were kind of classic cases of joint ownership, with 2 people on the title. But it's also well established that these principles apply, where there's only one person on the title and it's someone not on the title at all seeking to establish a beneficial interest. There's a quote there from Lord Walker's judgment, again in Jones and Kernot, which kind of sets out the court's approach to this, which I'm not going to read out again, but essentially, there's an additional hurdle for a party who's not on the title to show that there is an intention that they should have any kind of interest at all. And so taking all that together, it leads in to Hudson and Hathaway Court of Appeal decision. And on this slide, I've got the facts of the case, which I'm going to go through because they're quite interesting. It provides context for the decisions that were reached at the various stages. So in this case, claimant Mr. Hudson, defendant Miss Hathaway started their relationship in 1990. They never married, had 2 sons, and in 2007 they bought the property known as Picnic House in joint names with, surprise, surprise, no declaration of trust. In 2009, they separated. Mr. Hudson moved out. Miss Hathaway remained there with the 2 sons. And over the years, Mr. Hudson's mortgage contributions far exceeded Miss Hathaway's. Following the breakup, various emails were exchanged between the parties between 2011 and 2013 discussing financial arrangements. You'll find some extracts from them there on the slide. Mr. Hudson in these emails said things like, in relation to the property, I want none of the proceeds of that. Either take it, buy yourself somewhere you can afford to live. And under this arrangement, I have no interest whatsoever in the house. So whilst I'll continue to contribute, I won't do so forever. From January 2015, Mr. Hudson ceased contributing to the mortgage and Miss Hathaway took over payments. And then a number of years later in 2019, Mr. Hudson issued proceedings seeking a sale of the property and equal division of the proceeds. Perhaps unsurprisingly, given those emails and what was exchanged, Miss Hathaway contested these proceedings and contended that actually, she was entitled to hold the proceeds under a constructive trust that had arisen. She broadly argued that the various emails, some of which we've just kind of discussed, evidenced the agreement and the clear common intention that she should have the entire beneficial interest. And in reliance on this, she suffered detriment in various ways, including things like not paying all the mortgage from 2015 and relinquishing claims against Mr. Hudson's other assets following the breakup. And there are some other examples there on the slide of what was actually pleaded. At first instance, the trial judge, Simon Judge Rolton, found in favour of Miss Hathaway. He determined that the emails were evidence of a common intention and that she'd relied on this to her detriment by relinquishing the potential claims against Mr. Hudson's other assets. And perhaps importantly, a lot of the other elements relating to detriment or reliance which were pleaded were actually rejected. The decision was appealed by Mr. Hudson, and on appeal, Mr. Justice Kerr again found in favour of Ms. Hathaway, but he went a bit further and determined that as the common intention was established by the kind of express agreement in the emails, he didn't consider that detrimental reliance was actually required at all, and that she succeeded in establishing the constructive trust just on that agreement that was found. And just to cover all bases, he determined that even if detrimental reliance had been required, the trial judge had been entitled to find on the facts that it had been established. And the reasoning for this finding, detrimental reliance not being a required element is there on the slide, an extract from the judgment, paragraph 61, where he said, by not dealing with the issue of detriment in Jones and Kernot, the Supreme Court either omitted mentioning for completeness that it did not need to be proved in the case before them, or omitted to mention a crucial element of the relevant principles to be applied. In my judgment, the latter is less likely than the former. And so essentially, because it wasn't mentioned in the case of Stackenhauer and then Jones and Kernot, particularly when we think about paragraph 51 listing 1 to 5, there's no mention of detrimental reliance. He felt that it wasn't a required element where that agreement had been found first. And the court didn't then need to look at the kind of conduct and the change of position. The case was then appealed again to the Court of Appeal, and quite surprisingly and interestingly, at the prompting of the court, Ms. Hathaway applied to run an entirely new argument alongside the constructive trust one. This being that the emails that had been exchanged between them, between 2011 and 2013, actually satisfied the formalities of Section 53(1)(c) of the Law of Property Act, with the effect that Mr. Hudson had already released his beneficial interest to her in that way. And the wording of that provision of the Act is there on the slide, and it effectively requires a disposition of an equitable interest to be in writing and signed by the person disposing of the same. Understandably, Mr. Hudson and his representatives objected to this new argument being run on various grounds, and I think were quite annoyed that it had been raised at all. But the Court of Appeal ultimately allowed it on the balance of justice. And so what the Court of Appeal was ultimately asked to determine was, firstly, did the communications and the emails comply with the necessary statutory formalities, with the effect that the beneficial interest had been released in that way? Secondly, must a party claiming an increase to their beneficial interest have acted to their detriment, or is common intention alone sufficient? And finally, if it is the former, detrimental reliance is required, was the trial judge right to decide that Ms. Hathaway had established detrimental reliance? Justice Lewison gave the leading judgment, and in relation to the emails, it was held that the wording of the emails themselves did amount to a disposition of equitable interest for the purpose of the Act. Disposition was held to have quite a wide meaning, and in relation to the formalities, it was held that the emails signed off Lee Hudson were sufficient to comply with the formalities of the Act. And there's again an extract from the judgment there, paragraph 67, which is quite interesting, so I will read it out, where it was said, there is therefore a substantial body of authority to the effect that deliberately subscribing one's name to an email amounts to a signature. Given that so much correspondence takes place nowadays by email rather than by letters with wet ink signature, it is, in my judgment, entirely appropriate that the law should recognise that technological developments have extended what an ordinary person would understand by a signature. And so this decision and determination alone was enough to dispose of the appeal in Ms. Hathaway's favour. But the court still considered it appropriate to deal with the other questions relating to detrimental reliance. On these issues, in relation to the fundamental question of is detrimental reliance still a necessary element, it was held that that it was, and you'll find the extracts from the judgment there. I'll read out the first paragraph from 107, which is, I do not therefore detect in either Stackenhauer or Jones and Kernot any intention on the part of the court to abrogate the long-standing principle that what makes an unenforceable agreement or promise enforceable in equity is detrimental reliance. The principle of detrimental reliance was not challenged in either case, and that is why it was unnecessary for the court to deal with it. And so just because Jones and Kernot and the judgment hadn't specifically kind of addressed detrimental reliance, it didn't mean that it was no longer a necessary element. It was just that it was never disputed in that case. So it was, it was unnecessary for the court to actually deal with it. But it, it was long established by the previous cases, in the court judgment, that it was a required element. In relation to the second question of, as detrimental reliance is necessary, had Ms. Hathaway established this, it was held that, and the quote from, slightly paraphrased from a couple of the paragraphs is there, but essentially, this is an evaluative decision for the trial judge, and, as the trial judge had asked himself the correct question in determining detrimental reliance, it wasn't the court's place here to kind of step in and change that. They couldn't say that the decision was perverse, and so all in all, everything really in favour of Ms. Hathaway, and an interesting case. I think it will make us all look at the emails exchanged between our client and the other side in disputes like this in a lot more carefully, and I think it reaffirms what I personally understood, and I think most people understood, that detrimental reliance is a necessary element in establishing a common intention constructive trust. Although I understand this decision is being appealed again, so I think we'll have to kind of watch this space for any further developments. So finally, how should personal representatives deal with claims relating to the estate? The fundamental kind of point is that PRs are duty bound to administer the estate, and this involves them having a duty to collect in and secure the estate assets, and so this may therefore obligate them to bring or defend to proceedings on behalf of the estate. The estate and the beneficiaries could be severely prejudiced and suffer a real detriment if somebody claims an asset and it's not contested, and they take it away from the estate and take away perhaps even all the value of the estate, or there's an asset which rightfully belongs to the estate which isn't claimed. Naturally, when these claims are kind of first arise, PRs will think, what are the consequences to me? What are the risks? What's going to happen in terms of costs of getting involved? Part 46.3 of the CPR provides that where somebody is dealing with proceedings in the capacity of a personal representative, there is a general rule that they're entitled to their costs from the estate on an indemnity basis. However, this is qualified by the practice direction, which elaborates that these costs must be properly incurred for the indemnity to apply. And whether or not they were properly incurred will depend on all the circumstances of the case, including whether the PR obtained directions from the court beforehand, and whether to bring or defend the proceedings acted in the best interest of the estate truly, or in substance for a benefit other than that, including their own. Or finally, acted in some way unreasonably in bringing or defending the proceedings or in their conduct of the proceedings. So perhaps if any claim or defence was absolutely hopeless, the court aren't going to be happy and allow costs where it really shouldn't have got that far. So where that leaves us and where that leaves PRs is with a lingering kind of risk of personal liability. There is this potential indemnity that can be applied as a general rule, but there's the court also has full discretion not to apply that. And so PRs have to think very carefully about how they should proceed. Another consideration really has to be what will happen if the estate is unsuccessful and that asset is taken out of it. If it's the only value in the estate, then there's going to be nothing there, even if the indemnity is applied, to pay the costs, and they might then be stuck with personal liability for the costs. And so all these things have to be considered. Quite often these cases involve lay personal representatives who are also perhaps even the only residuary beneficiaries, in which case they have a clear financial interest, and no kind of other beneficiaries to answer to, in which case it's kind of on, if they're happy to take on the risk of litigation, it's quite an easy decision for them to make. But it's obviously more problematic when you've got a professional PR or a lay PR with no financial interest, and they're thinking, am I going to get involved in this for no real benefit for me, but potentially get stuck with all these costs? And so, to protect against the cost risks, there's a few steps that can and should be taken. There's other steps as well, but those listed on the slide would be, of course, obtain advice on merits, of bringing or defending proceedings from counsel if necessary, as early as possible, so you can make an informed decision as to how best to proceed. PR should always kind of consult with the beneficiaries and seek their agreements to bring or defend any proceedings, and set out the estimated costs of doing so. Ideally, you might get the beneficiaries to sign something confirming their agreements to a course of action, and to the estimated cost being deducted from the estate, regardless of the any kind of court order or outcome. And if the estate is insufficient, and there is this risk of there being nothing there to meet any costs, even if the indemnity is applied, you can potentially ask the beneficiaries who do have a financial interest to to maybe underwrite or agree to underwrite any costs which might not be recovered at the end of the proceedings. It's in there, it's for them to recover this. So obviously there's lots of situations where beneficiaries won't all agree, in which case the PRs can consider applying for a better order. Counsel's opinion on merits will be required, and this will essentially ask the court to exercise its discretion on costs in advance, and they'll know whether or not this indemnity for their costs will be applied regardless of the outcome. And finally, PR should of course kind of conduct themselves reasonably, follow advice, and they should really consult the beneficiaries throughout, particularly on things like settlement negotiations, seek their agreement to any proposed settlement. If this is not agreed, or just the approach generally in the proceedings, then the PRs can consider applying to the court for directions on how to proceed under Part 64. So thank you very much. That's the end of our talks. If there's nothing else, thank you very much for attending, and we hope to see you all kind of at other events soon.
Thank you very much.
Thank you.